rights of nature is gaining prominence so quickly. But as we all know, like all good ideas, rights of nature faces a challenge that it's in the midst of right now. And that's the idea of the devil's in the details about how, if, and to what degree that vision is going to work in practical reality. One thing as an environmental academic that I really am inspired and challenged by in our current landscape of environmental governance challenges is how this is one example of a green versus green dispute.
The rights of nature, a brief introduction, is just the idea that nature has basic fundamental rights just as humans do. Outside of the US, the rights of nature is at the highest levels of government. It's working. There's been a lot of learning along the way and some setbacks, but it is having a real impact. But what about in the United States, the belly of the beast of capitalism? Local communities in the US started passing rights of nature ordinances, saying nature has rights in our town, and we're going to therefore fight against fracking and CAFOs and so forth. Local governments are preempted by state and federal laws that have legalized pollution wholesale across the United States. That's why we're in this mess. There's a lot that local governments can do, and we're doing it with them now. Local governments can pass non-binding, persuasive, or other less aggressive instruments to recognize the rights of nature at the local level. If they do this, they can integrate nature's rights into the community fabric. They can also appoint legal representatives of ecosystems at the community level with people who are part of those ecosystems. There's nothing in the law that says we cannot give nature a voice legally. And they can call upon state governments to pass stronger laws to address the rights of nature. And this is the strategy we're taking in the Rocky Mountains, working with local communities, passing laws, building awareness of nature's rights. And then when the state governments pass these sweeping laws on the rights of nature, the local governments will have the institutions and the cultural awareness to really make the most of it. And you can even locally pass trigger laws. And this is something that I've learned from the anti-abortion playbook, where all these states passed trigger laws that would prohibit abortion in various ways once the Supreme Court overturned Roe v. Wade, which they did. And then everything was in place to create this new system. And then I also think we need to organize to train lawmakers, such as through an earth-centered alternative to the Federalist Society.
Really in total agreement with, I'm sure, most of the people in this room about the scale of the problem. And simultaneously, I believe that rights of nature are taking us in the wrong direction. First and foremost, the vagueness of nature's rights. An effective environmental law has to give some notice and some guidance to humans about how to conform our behavior to the law. Do the statutes truly mean that every living being has a right to be left alone? If so, what does that mean for the fishing industry, for all of agriculture? Are humans allowed to dispose of treated sewage in a river? If a statute says that a river has a right to be free of pollution, then presumably the answer is no. But if that's the case, then what shall we do with our sewage? As practical law, it leaves so many questions unanswered. And the answer, I fear, is judges. Judges are being elevated and empowered to decide what the meaning of nature's rights is and how they would apply in different situations. We should keep in mind that in about half the states, judges are elected. Judges are out there campaigning. They're raising fundraising dollars just like politicians, and largely from corporate interests and very powerful interests. But of the 50 or so ordinances that have been enacted, 5 have been challenged in court, usually by industry, and often on vagueness or other constitutional grounds. And in all 5 of those cases, the courts agreed with the plaintiffs and struck down the ordinances. And the same kinds of arguments could be used against construction of schools, construction of hospitals, construction of mass transit, and construction of renewable energy. It's all the infrastructure we need for climate adaptation, all of which could be targets of rights of nature lawsuits because they will harm nature. They will kill some living beings to do those necessary steps to address climate change.
We are comfortable with a broad right of free speech that is then nuanced through case law and legislation. Why is vagueness okay with the rest of our Constitution, but not with the environment? Constitutional environmental law is a robust area of scholarship and advocacy. While I see potential in the right of nature, I see at least 4 challenges that need to be addressed. First, a question that's often raised, who speaks for nature? How do you know if the self-appointed advocates are actually speaking for nature, not for their own beliefs? Nature can't fire her attorneys if she disagrees with the arguments that they're making. Second is the question of scope. Do all natural features have rights, or do only certain natural features? Third, there's the question of how we manage the tension between rights of nature and human rights. Does the right of nature mean that water needs to be taken away from meeting human needs? My fourth and final question, though, is the one that I really struggle with. And that's, what is the value added of the rights of nature above and beyond the right to a healthy environment? Is there something that would change? I mean, let's suppose there was a country that has a right to a healthy environment. What would they get that would not be protected by that? In conclusion, I am intrigued by the potential of the rights of nature. There are many questions that need to be worked through for it to scale up. That said, I do believe that the rights of nature has legs and a future.
Well, think of Earth law as a tree. And there are currently many different branches on the tree of Earth law, some that will fall off and new ones that will grow. So with what we focused in on today and some of the challenges, but also opportunities of rights of nature, that's only one branch of the tree. I actually think that Earth law as a broader concept goes beyond rights-based frameworks to include, for many indigenous legal systems, what are often known as responsibility-based frameworks. And so to think of rights of nature as maybe the first step, but not the ideal step, is appropriate for us in a context of trying to navigate these really complex settler colonial imposed systems that we've had to operate within for hundreds of years. But perhaps we can start to interject different values through rights of nature and other branches of Earth law that allow for more transformations of our broader legal systems. We were able to put together a global data set and database of these initiatives, and there are thousands of them. Or you can go to ecojurisprudence.org and you'll see that there are thousands of initiatives around the world that have picked up different aspects of Earth law and are captured in this online data set. The Earth Law Center is actually launching an international database that has resources and templates of all different types of Earth law initiatives that have emerged and will emerge in future years and decades. What we are seeing broadly around the movement is youth leadership and youth voice. And I want us to recognize that, maybe myself included, we might be the old people in the room. We might not know exactly where the future of the planet should go. And perhaps taking a step back and asking, what is the vision that youth around the planet have for their legal system? Because that's what they are inheriting and going to be leading. It really is, because many of you sitting in the room today and others not with us, but who are actively engaged in these spaces, are going to be creating those new branches that will emerge on the tree.